In early 2026, we gathered a panel of leading experts in the field of shareholder disputes at the office of Laytons ETL. The panel comprised Barrister Paul Mitchell KC from 4 New Square, forensic accountant Daniel Djanogly and tax expert Jamie Muirhead from Wilder Coe, and myself, Geraint Thomas, the head of disputes at Laytons ETL, with my litigation partner and regulatory expert, Ben Thorogood.
Episode 3, Injunctions.
Because it's easy to spend an absolute fortune on unfair prejudice petitions and choosing which battle to win. You know, this, I think Geraint's point about the early interview with the client, where you really extract as much information out of them as you can, so you can choose 2 or 3 strategic steps, you know, to try and bring things to a head, is very wise.
One of the aspects in this of this sort of dispute story is that it might be that the unfair prejudice has been manifested in some sort of extraction of value in different ways from the entity. Now, a valuation exercise focusing on valuation won't necessarily pick that up. So what I was describing, I guess, is a folk where the scope is limited to the question of valuation. But if there's a concern that the offending directors have, director shareholders have been, you know, using dummy companies to take value out, as I say, there needs to be an inquiry of some sort, some investigation built into the exercise. Now, once you open that discussion up, then you're going to find, I guess, people defending themselves.
I'm sure
and then you have a fight.
We've all been involved in the kind of case where there's a new co.
Yes.
And where all the value seems to have somehow made its way into Newco, and Newco then gets roped into the dispute in some way.
Yeah, I mean, very often by way of injunctive relief. Yeah. You know, in my experience, is when people have discovered that there is this kind of bleed of quite often information more than, you know, more than actual cash, because cash you can get back. But once an idea is out of the bag, then it can be very, very difficult to put things back together again. So that kind of injunctive relief can be a very early, useful step.
In terms of trying to get on top of the detail at an early stage, it's I think it's becoming increasingly difficult because of the quantity of documents or data that exists in this modern world. It's not just a case anymore of sitting in a room for an hour or 2 trying to capture the recollection of the client's memory of certain events that may not have happened in the last few years.
There are 2 things here that I'd like to talk more about, and one is injunctions and the potential impact that they can have on a dispute. To discuss injunctions, which in shareholder disputes are a tool regularly used to apply commercial pressure to obtain advantage, and can often lead to the early resolution, in my experience, of a dispute. In fact, we've already talked about this, haven't we, Paul? And the scenarios can differ between your the scenario that you mentioned to me, where a company is an active party within a shareholders dispute, and the scenario we were talking about earlier, where the parties are just the shareholders, and that can have an impact if an injunction award is made in constraining the spending that those in control of the company are able to make. So is it? I'll ask the lawyers if you'll forgive me. Is it? Would you consider seeking an injunction award in every minority shareholder action, or are there particular kinds of minority shareholder case that particularly lend themselves to the making of an injunction application?
Well, I would say because the injunction is such a nuclear weapon, because it restricts the ability of the company effectively, or the respondents to the petition, or both, to carry on in the usual way. The courts are usually very they apply a great deal of scrutiny to the proposition that an injunction should be granted, and they're also very aware that injunctions do, on one view, grant, a huge advantage to the person who's got the benefit of the injunction.
Can you give us an example of what an injunction might sound like?
Well, I mean, the one we've been discussing earlier on between ourselves was the kind of injunction where if there are only shareholders involved in this dispute, even though some of them are also directors of the company, those who are directors of the company might be tempted to use the company's resources to pay for the defence of the action, where, of course, the minority shareholders would consider that those resources should stay at the company because the dispute really arises from the unlawful behaviour of their fellow shareholders wearing their cap of directors. So you might get an injunction that says, well, in this particular case, the respondents are to fund the defence of the action from sources other than the resources of the company in the first instance. But in that, I mean, you can see that kind of order obviously changes the risk of litigation dramatically for the respondents, because they are personally exposed to funding their own costs and indeed to adverse costs if they lose. So the court is going to be quite careful to ensure that the playing field is not, well, it's not being tilted unfairly one way or the other, because you will be complaining that the playing field has been tilted against you as the minority shareholder, and you'd have to persuade the court at the injunctive stage that there was a pretty good chance that you were going to establish this, and that it is right to hold the ring in the way that you've suggested. And so to Geraint's question, is it worth considering? I mean, it's always worth considering, because if the facts demand some kind of remedy, then it's going to be one of the first things in your toolbox. And I think, I mean, it's fair to say that it is not a weapon which is available to all litigants in all circumstances, and you just need the courage to use it. It's more the case that if the facts are such that it's a potential remedy which is going to be very useful to keep your client in the game, then yes. And of course, Geraint's point is that if you've got an injunction, then the chances of settling the case do increase. I mean, there's no getting away from it because it is such an imposition on the respondent.
Can I add to that quite often what you get in these disputes is instances where those in control of the company want to take it in a different direction. Mm-hmm. And that may involve expenditure that of a kind that historically hasn't been made, or there might be dividends planned that of a kind that historically hasn't been made, or they might start dealing with a new counterparty, which again might involve it would be particularly interesting to the aggrieved party if that turned out to be a close connection, that they, through some digging, were able to find out that the party that they were concerned about already had a relationship with of some kind. So those kind of concerns really open the door to an injunction application, but then with the benefit of the control over costs you can get out of it as well, you can see if you're preventing your counterparty from being able to do any of the things that they actually want to do with the company, and you're controlling their ability to fund the defence of the litigation, then that's a really big stick.
But it needs to be, you need to approach it with some quite extreme caution though, because even if you're able to obtain an injunction and you can quite soon thereafter lose the advantage if you haven't followed all of the right steps, or they come with tremendous duties to the court to provide proper disclosure even of the things that would be said against you if this is something that's done on no notice or short notice. And if a misstep is made at that initial stage, that advantage that you gain can quite soon be removed or tipped the other way at a return hearing. There has to be the right set of facts, but also done in the right way to be an actual advantage to them.
So how restrictive are the injunctions that you tend to be looking for in that case? So if you paint a bit of a picture for me, is it just extraordinary payments that you'd expect that there would be a stop on, or can it sometimes be an impediment or routine trade as well?
Well, the routine trade thing probably wouldn't ever really be, because how could you stop routine trade? It's more like, I mean, if you take, for example, I had one where a company of idealists had gone into I can't tell you the area of business because it would be so obvious who they are, but they'd gone into an area of business which was new, very much targeted at kind of Gen Zs. Three of them wanted to take it into a much more kind of corporate, traditional, let's just make money kind of approach. And the last one didn't, on various ethical grounds. And so the last one, who was by this point, of course, a minority shareholder, wanted to restrain the company from entering the business relationships that it was going to enter, which effectively, in that shareholder's view, meant selling out. And the oddity there was that that shareholder was going to get richer as a result of going down this path, but had this ethical determination not to go down this path. In that case, nothing happened. So, but the idea was, and what the client wanted was to restrain the company from going down that path. And you could see, for example, if somebody has got an invention which has got a very kind of expensive proprietary IP in it, and the proposition is to merge with another company. You know, the moment things have started down that path, the prospects of losing the value of that IP, get higher and higher with each day because of the due diligence process and all the rest of it. And you can see, in theory, if somebody were able to put together a case that this proposed merger were actually a catastrophe for his or her interests or its corporate interests, seeking to restrain it might be something that people would seek.
And they didn't have to grapple with that as a final remedy in your case, but is that something you think the court could and would grapple with, preventing it from going down a path that objectively might make them more money?
Well, I think actually it's very difficult to say. I mean, given that companies are not moral entities, I mean, directors have fiduciary duties. You can't choose to manage the company in a way which deliberately or knowingly prejudices the economic interests of a minority shareholder. So I think if you're taking decisions that are going to make everyone richer, it's quite hard to see, save in extraordinary circumstances, how unfair prejudice would be the route forward. But I think in commercial circumstances where you're asking the court to prevent a company from making choice A so that it can make choice B, if you persuade the court that choice A is in fact one which will only be made by breaches of fiduciary duty on the part of the directors to the prejudice of the minority, and the best way forward is indeed to hold the ring forever or to make a permanent injunction, why not? I mean, you'd have to think of a factual scenario where that made sense, but I think the court's powers under Section 996, which Geraint was just reminding us of, I mean, they are extremely broad.
Yes, and I suppose you might get a scenario where if people set up a company that was designed to pursue an ethical agenda, they might reflect that in the articles or in a shareholders
The
agreement.
moment it's all written down, things get so much easier, don't they?
Yeah,
But you'd give rise to a breach of contract claim or
maybe.
Yeah.
something.
Not necessarily in the articles, though. If the articles set out a broad statement as to the agenda for the entity.
Well, traditionally, it's your sort of memorandum of understanding or your objectives through and that type of thing, but that seems to have fallen away from corporate governance, I think, hasn't it? But yes, if you're going to pursue a moral or other objective that doesn't necessarily realise in only financial interests, and maybe that's the route to try to protect yourself.
But I think we're obviously talking about very unusual examples which illustrate the point. But when it comes down to this original question about using injunctions, I mean, Geraint's question is should you be thinking about it? And I think the answer is clearly if your clients are being put at an obvious disadvantage and it just stands out to you as you understand the case, then it probably is going to be something you'll need to dig into. But Ben is absolutely right that injunctions are expensive because of effectively the due diligence you have to do before you get to a court, and because you're usually in a hurry, the time that you have to do the extraordinary level of due diligence you need to do to present the case fairly in the absence of the other party make them quite a dangerous proposition, because it's always possible that in the short time scale and the huge amount of work, something which actually does turn out to be tremendously important falls through the cracks and the team just hasn't picked it up. The client plus barrister, solicitor team hasn't picked it up. And it can blow up in your face. So you need to have a very solid argument for your injunction before you go down the path of taking the risks associated with it.
So, in summary, very high risk, very high reward.
Yeah.
So, yes, always worth thinking about at the outset, particularly where your counterparty, if they're in control of the company, appears to be doing something that you find objectionable, or about to do something that you find objectionable. So,
I suppose this is the murky line between conduct of a business that might be unfairly prejudicial and actions that may be fraudulent.
Yeah.
And it's not always clear which one you're dealing with, at least because when you're trying to assess the position, you don't have all of the information and the documents.
What's the not alternative? What's the opposing? Is there an opposing injunction that could be introduced? And that the first injunction is considered itself to be unfair.
Well, I think in terms of...
Is it a backup injunction?
I think in terms of early wins or ways to protect yourself, if you're one of the respondents to these types of claims, then making an early offer to purchase the claimant's petitioner's interest for proper value, that is not an injunction, but it is a pretty effective mechanism for protecting yourself to these types of actions, because if a proper offer is made in those terms, and it's not easy to do, but you capture all of the right prejudice that is alleged to have, then you can try to strike out the legal actions brought against you.
Because we're talking about the Section 996
Well, that's certainly one of the
drivers
Yeah.
routes in.
Yeah, so yes, what I'm referring to isn't an injunction. I don't think there is an obvious injunctive relief as a respondent, because...
But it's maybe worth talking about the process by which you obtain the injunction, because if you apply, as Paul says, on initially without notice, then there'll be that initial hearing where if you persuade the court to grant the order, you will have the order, but only for a short while, because then there will be a return date appointed for the injunction when the court has the opportunity to hear from the other side as to what they have to say about all this. And that's where, if you've applied without notice initially, then you owe a duty to bring all the information, all the arguments that the counterparty would have raised had they had the opportunity to be there, to the court's attention. But pretty much always what the counterparty will say is, well, they didn't say this, they didn't say that, they didn't draw your attention to this document, they didn't draw your attention to that document, and it's all nonsense anyway, it should never have been awarded. So they will have an opportunity to try to get the order discharged, and obtaining a costs award against an injunction application against the party that applied for the injunction in the first place. It means that their case hasn't got off to a good start, and it may be all downhill from there. So, as I said a moment ago, high risk, high reward.
Yeah, so that's the sort of response to this injunction.
Yeah.
But what I was trying to sort of deal with was I think the equivalent, trying to gain an early advantage or to mitigate exposure. That's the route that I identified. You make a proper offer, and if they do try to persist with the proceedings, then you can apply at an early stage to have those proceedings.
So